Good morning, everybody. We are delighted on behalf of the Georgia First Amendment Foundation and the First Amendment Clinic at the University of Georgia School of Law to welcome you to this session on open government and social media essentials. We have a lot of ground to cover today, and we have a lot of people here signed up. I do want to make clear that we are recording this session and will be publishing it to the Georgia First Amendment Foundation website. I would ask that you please turn off your cameras and place your screen in presenter view mode or active speaker video mode. It will have you look at the screen and then the person who's speaking, but will make it harder for other people to distract you. I would ask that if you have questions, you put them in the chat. My Georgia First Amendment Foundation colleague, Kathy Brister, the immediate past president of our organization, will make sure we don't overlook those questions. So she will be keeping Clare, Isabel, and me on point that we don't miss those questions from you. So if you put them in the chat, we'll make sure we circle back on those. Let me start off by introducing my colleagues doing the presentation today. Isabel White is a second-year student at the University of Georgia School of Law. She's enrolled in the First Amendment Clinic, and she graduated from Emory University in 2020 with a Bachelor of Business Administration. She's previously worked as a legal intern with the University of Georgia's Office of Legal Affairs. Isabel is originally from Falls Church, Virginia, and we are delighted to have her working with us on this training. Clare Norins is a veteran of training with the Georgia First Amendment Foundation. She is a clinical professor and director of the First Amendment Clinic at UGA's law school. In private practice, she's represented plaintiffs in First Amendment and other constitutional claims, focusing on issues of policing and employment discrimination. She served as an assistant attorney general for the state of New York and as assistant director of UGA's Equal Opportunity Office. She is a board member of the Georgia First Amendment Foundation, a very valued one at that. I am a retired journalist. For 43 years, I worked as a reporter, producer, and editor at local television stations, at CBS News, and the last 20 years overseeing editorial quality control at CNN. I now do a lot of teaching at the University of Georgia, the University of North Carolina, and at Franklin Pierce University in New Hampshire on open government ethics, media ethics. And I do a lot of training with the Georgia First Amendment Foundation for the building on the importance of open government community trust building and local journalism. So let's get started with our little talk here and see if I can get the presentation to move forward one page. So the first part we're going to be talking about is Georgia's open records laws. And before we get too far along, a little legal fine print. This presentation contains general legal information current as the date we are giving it. It's not intended to be legal advice. I am not an attorney, although we have Isabel, who is trained to be one, and Clare, who certainly is an attorney. We are not providing legal advice to you, but we are giving you guidance that will help you as you work with the Georgia open records laws. The next thing I want to point out to you is that everything we're going to be talking today pretty much in relation to open records and open meetings can be found in the open government guides that are available at gfaf.org, Georgia First Amendment Foundation.org. gfaf.org is the website. The books are available for free as a download, as a PDF. You can also pay a small fee and receive hard copies of these books. The Red Sunshine Laws is largely what we're going to be focusing on today, with some from the law enforcement guidebook, the Blue Book. What we're not covering today is the Guide to Court Access in Georgia, which is also a terrific guide just published last year on how you can obtain access to Georgia's courts. So looking at Georgia's open records laws, the principles of open government come from four sources: the state constitution, state common law, and case law, and most important for our discussions today, the Georgia Sunshine Laws, the Open Records Act, and the Open Meetings Act. Georgia has a long tradition of open records, which was vigorously reaffirmed by Georgia Chief Justice Charles Weltner in 1992 in the case of Davis versus the city of Macon. And he wrote then, and this has been repeatedly quoted in litigation in support of open government. It's been cited countless times in judicial rulings from other judges. His line is, because public men and women are amenable at all times to the people, they must conduct the public's business out in the open. And the preamble to the Georgia Open Records Law makes it very clear that it's the strong public policy of this state is in favor of open government, that open government is essential to a free, open, and democratic society. And exceptions to the Open Records Law shall be interpreted narrowly. That's really important as we get into the exceptions portion of the Act in a little bit. So what's covered under Georgia's open records laws? Any agency, commissions, councils, boards, authorities, school districts, subdivisions created by a branch of government, and interestingly, nonprofits who receive a third of their funds from government sources are covered under the Open Records Act. Private entities that carry out government functions. So those water boards that maybe are private enterprises that are providing water services for a city or a community, they are covered under the Open Records Act. Records. What's the definition of records? Well, it's documents, data of any kind, letters, maps or books, tapes, photos, emails. We'll come back to emails again. Data, personnel records, zoning records, electronic files. Did I mention email? Zoning records, decisions from zoning boards, budgets, reports, and key here, any drafts of reports, any work that is the product of government action are covered under the Open Records Act, with some exceptions you're about to hear about. Certainly digital things are covered under the law. It's not just printed pages. Georgia's Open Record Act applies to electronic data, including email, that email again, and text messages. I won't get into the specifics of the act, but you can, if you download the guide, you can find those pages. And while the statute does not specify it, the Georgia Attorney General's office has taken the position that all email, that email again, and text messages concerning the agency's business are open regardless of whether they came from a state account or a county account or a personal email account. So if a public official is using their private email to conduct government business, those records are required to be open. So what's the process of applying for documents or records through the Open Records Act. You should know that written requests are not required. You can request something verbally, but we at the Georgia First Amendment Foundation strongly recommends written requests if you're going to ask for a record. Now, if you're in the police department and you're looking for an incident file and you can give them the number, or if you can talk about the specific episode and the sheriff's deputy is sitting right across from you, written is probably not required. But most of the time, it's better if you put it in writing. It avoids confusion, and it also creates a paper trail when it comes to the time that the agency has to respond, which we'll get to in a little bit. There is an exception to the requirement, or rather the waiver of written, and that is if you are an attorney or someone who is pursuing litigation and seeking to get a record related to that litigation, you do have to provide that request in writing, and you have to copy it to the agency's attorney of record. Now, all public records are presumed to be open to inspection and copying, which means that you could go in with your cell phone and simply snap pictures of the relevant pages. They don't have to make it hard for you by charging you a fee for copying if you can copy it yourself. An agency can require that all written requests go to a dedicated person. Someone's called a records custodian. Records custodians are the people who maybe channel all the requests for a particular agency, particularly larger agencies. They have the right as an agency to determine that this person is the person that all the open records requests go through. Now, the trick here is that for the agency, they can't slow the process down by using a records custodian. They have to be able to respond in the same time frame as if you had sent that request for a record to the person who has the record. It is a convenience for the agency, not an inconvenience for you. So bear that in mind as you work with a records custodian. Very often they are very up on the process and move things along. Typically, records that are readily available, i.e. they're not in storage, not hidden away somewhere, or not needing redaction for things like a social security number or other details. They're supposed to be made available as soon as possible. No 3-day wait for those items. The 3 business day rule in the Act gives the agency a deadline to respond, telling the requester when the records will be available if they're off-site, how much copying them or processing them is going to cost, and cite specific exemptions to the Act if they're going to be withheld from you for some reason. But 3 days, 3 business days, it's very key. If you ask for a record on a Friday, it's not Monday when they have to tell you, it's Wednesday. So you're seeing UGA there in the background of this graphic. Exemptions to disclosure under the Open Records Act includes veterinary information, veterinary records. So you will never know or be able to obtain the veterinary records for UGA, the Georgia bulldog. Also medical records, if they're a disclosure or invasion of personal privacy. Records of law enforcement, prosecution records, or regulatory agencies who are working on any pending investigation or prosecution of criminal or unlawful activity, other than initial police reports and initial incident reports. And we'll get into that a bit more later. So anything that is current or pending in a prosecution or investigation of unlawful activity, they can legitimately withhold from you while they work on those matters. Records of athletic or rec programs available through the state. They don't want people knowing the home addresses of the 9-year-olds who are playing Little League. That includes information by name, address, or telephone number. Records of the state tollway authority. If you're driving up and down 85 in the Peach Pass lanes, your financial accounts or travel history is not available as a public record. You can seek out how many times has Richard Griffiths driven up 85. Some exemptions to disclosure. Records containing income tax matters or income tax information that are generally confidential under state or federal law are exempt from disclosure. I should note here that property tax records under Georgia law are always public. So records related to the Georgia Access to Medical Cannabis Commission are excluded under provisions written into the HOPE Act passed 3 years ago. I should note that the commission is actually recommending the legislature revisit the sweeping exemptions granted that agency because it is affecting their credibility as an agency if the public can't see what's going on, that made those recommendations in their latest annual report. There's still some things that they want to keep secret relating to the bidding process, but it's something that we're working on and hope that we'll get some more clarity on in the next few weeks and months. Personal information collected by agencies isn't public and includes your mother's birth name, your social security number, your financial information, account numbers, insurance or medical information, unlisted phone numbers, and your date of birth. Public employees are also covered by those same exemptions about birth name and social, etc. But the exemption does not apply to non-personal information. So job applications for employees who sought a job at state government, performance evaluations, if an employee received disciplinary action, their personal files and their salary are public records and can be sought by the public or a journalist or the employee themselves. The caveat to exemption, of course, is dates of birth, social security numbers for news gathering. So if you're a news organization and you're working to see whether the Richard Griffiths who's just been arrested is the same Richard Griffiths who works for the Georgia First Amendment Foundation, you can seek from the agency either the social or the date of birth, so you can make sure that that Griffiths is the correct Griffiths that you're doing your story on. Excuse me here while I make sure that I'm in the right place in the presentation. So one of the sad things about the Open Records Act, a disappointment for the First Amendment Foundation certainly, and for open government advocates, is that the legislature exempted itself from the act. There is no requirement that the legislature turn over records, the same records that if it were in a county agency or a city agency, the entity would have to turn over. They exempted themselves from meeting the requirements of the act. And it became a big deal in recent days. Those of you who have been reading the Atlanta Journal-Constitution have been doing an investigation into what appears to be a junket of state officials going to Europe right before they left office on an economic development trip. And the legislature and the officials involved have refused to turn over the records relating to the cost of that trip, what they did, who they saw, what they were up to, citing this exemption. So let's see if you're going to be able to get a document. So you put your request in, and they say there's going to need to be some redactions in the document. If there are redactions required, those redactions must be made by the lowest cost qualified employee who is going to be taking on that work. And the records that are being redacted must be released when they're ready. They can't, if you're requesting 30 documents, they can't wait to release all 30 documents to you until they're all done. They're supposed to release them to you as they are completed or in batches. So they can't use redaction as a reason to withhold other records that are ready to be delivered. Interestingly, the document on the right was redacted by DeKalb County, citing national security. The whole report was redacted all the way through. And it turns out when they provided the document, they did that poorly. It took about 10 minutes to cut and paste those blocks into a Word file, and then it revealed the entire text and how it was a scathing review of incompetence and inaction in the IT department in DeKalb County. So using redactions to cover up the findings of a document is not good grounds to do that. It has to be, the redactions have to meet the criteria that we've already identified. Political embarrassment is not a good reason for redaction. So how much is this going to be cost, these documents you're obtaining? Well, they can charge for record production and copying, but they're not required to do so. And most of the time, agencies don't, if it's just 2 pages, they'll make those copies and provide them to you with a smile, either dropping them in the post or emailing them to you. Records are supposed to be produced in the most economical way possible. And the production charges are to be somebody who has okay, we got you. And I'm going to mute a couple of folks here who have not muted. Okay, I think we got it. Can everybody hear me okay? Presume so. Records are to be produced in the most economical way possible. Production charges at the lowest rate of qualified person. So if the copying can be done by an assistant to the director whose hourly rate is $25 an hour, that would be the fee charged. Though if it's just a couple of pages, the first quarter hour of that person's time is waived. And typically the copy charge is 10 cents a page. If they have to put it on a jump drive like this one, they can charge you the actual cost of that jump drive for electronic records. And the agency is supposed to notify the requester if those charges are going to exceed 25 bucks. If it is less than 25 bucks, they can produce those records and send you a bill for under 25 bucks. More than 25 bucks, they've got to seek your permission. If the cost of producing the records or the documents or the videos, whatever it is more than $500, the agency can seek prepayment. They can say, hey, if you want this, we don't want to spend all this time. If you're going to say, that's way too much, I'm not going to pay that. So they can say, send me the check, or here's the credit card number, if the charges are expected to exceed $500. The agency cannot charge for its time its attorneys spend advising whether records should or should not be disclosed. They can't hit you up for the back office legal consultations relating to whether the records are subject to the Open Records Act. Those are all on the agency. If there's a denial, the agency has to provide specific legal exemptions, including the code section, the subsection, paragraph, And they've got to do that within 3 business days. That's where it's really handy to go download the digital copy of the Red Book, which has the Act laid out in full in it. And you can look up the specific exemption and figure out whether you think it matches and whether an appeal is required, or you might choose to take legal action if it got to that point. The law doesn't require agencies to create records that don't exist. That's totally the agency discretion. So if you're wanting to know about all the wrecks at the corner of Main and Elm in Conyers, Georgia, the Conyers Police Department doesn't have to create a record that contains the 4 wrecks that were there last year. However, the law doesn't allow that to be grounds to deny the request if that information is available in another format. Maybe there's a list of all the accidents in downtown Conyers, and you can pull that information yourself from that existing document. Agencies do have to produce electronic records from the systems they use. So if they're using QuickBooks to do the accounting for a small town or a county, they can be required to turn over a QuickBooks file of those electronic records. For a database, they can provide them in an Excel file or an ASCII delimited file. They can't refuse data requests on the grounds that exporting or redacting data will require someone to generate an electronic record that's responsive to the request. So this is a little different than printed records where they don't have to create a printed report. In this case, if they can easily generate a report from an electronic record using filters, they can do that. And private vendors who are contracted to maintain government data are subject to the Open Records Act. So a municipality can't say, well, it's an independent water authority, they don't have to turn over the records. If they're doing the work of government, either maintaining government data or doing the work of government, they are subject to the Open Records Act request. And I see Joe Hirsch's question about the statute of limitations. We will get to that, and I will defer to Clare on that, because that is not an area that I know much about. So Clare, if you could take a look at Joe's question in the chat. So violations of the Act. Any person who knowingly and willfully, that's knowingly and willfully is a key phrase here, violates who knowingly and willfully frustrates or attempts to frustrate access to the records, are subject to a misdemeanor indictment or booking that if they were found guilty, they'd be subject to a $1,000 fine. And if they're caught for additional violations within a year, a $2,500 fine. Well, that's not a lot, but it's a criminal conviction, which of course is embarrassing if you're a public official and trying to move on to a new job and you've been found guilty of criminally violating the Open Records Act. You can also sue under civil action, and there's a $1,000 fine for the first violation and $2,500 for additional violations within a year in a civil action. That does actually have some teeth, and I'll get to that in a little bit, because it also covers your legal fees. If you win a civil action, your legal fees are paid, and we'll see how that played out in a couple of examples in a moment. One thing the Act protects is disclosures in good faith. So if a public official gives information and makes a mistake and accidentally puts my social security number in the document, maybe misses it in the redactions. They are covered under that. If that was an honest mistake, they cannot be sued for making that mistake. So let's look at a recent case in the city of Atlanta. This lady was the press secretary to the then mayor, Kasim Reed. And she was criminally convicted under the Open Records Act. WSB reporter Richard Belcher attempted to obtain the records of past due water bills from properties owned or occupied by then Mayor Reed, his family and friends. We're talking many thousands of dollars in unpaid bills. And the mayor's press secretary, as I mentioned, was Jenna Garland, and she had this exchange with the records custodian at the water department. And when the text surfaced, the Attorney General's office of the state of Georgia filed criminal charges, and it dragged on for a bit, but she was convicted and fined $1,000. And her appeal was just denied last year by the Georgia Court of Appeals. So, and then there was this gem, also with the city of Atlanta. Ann Torres, who was Jenna Garland's boss, moved to block a request again from that reporter, Richard Belcher, for Beltline CEO Brian McGowan's contract. And subsequent open records requests found the emails threatening the Beltline CEO. You're not obligated to provide anything to Belcher on Friday. The Beltline is only obligated to respond with an estimated timeline. You can hold it until the next week or another busy news day. Channel 2 complained to the Attorney General, alleging a culture of political interference with open records requests at City Hall. And they filed suit. Cox companies, the AJC and Channel 2. And since the Open Records Act allows attorney's fees in civil cases where violations are shown, the city ultimately ended up having to settle for $80,000 paying AJC and WSB's legal fees while promising to do better. Well, how many open records requests are too many? There's no limit. You can make as many as you want under the Act, as long as the requester pays the reasonable charges for producing the records. The law does not allow a number of requests to be grounds to deny records. And taking legal action against a person for making Open Records Act requests, either civil or perhaps criminal action that's been threatened in some communities. Civil actions would likely violate Georgia's anti-SLAPP statute, and criminal actions could well violate the Federal Civil Rights Act. So let's move on now to my colleague, Isabel White, and I will stop my video, and Isabel will pick up from here on Georgia's open meetings laws.
Thank you, Richard. Yes, I will be discussing Georgia's Open Meetings Act, which is broadly applicable with only a few exceptions. The goal of this law is to promote transparency and public confidence in our state government. Some of the agencies and government bodies that are covered by the Open Meetings Act include city council meetings, school district meetings, and local board of commissioner meetings. This photo in the background is of the 2019 Atlanta Task Force for Promotion of Public Trust, which was put together to increase transparency and accountability in Georgia state government. So what's open to the public? Whenever a quorum meets for official business, the meeting must be open to the public. Let me quickly define quorum. A quorum is the minimum number of members of a governing body that must be present to make the proceedings legally valid. 50% of the members plus one constitutes a quorum. And this quorum doesn't have to meet in person. Members can meet over the phone, on Zoom, or even in a group text message, and the Open Meetings Act still applies. To quickly define meeting, members must be formulating, presenting, discussing, or voting on official business, policy, or a public matter of the agency to make up a meeting. And there are a few exceptions that apply when members meet to inspect physical property, to attend relevant seminars or training courses, to meet with the legislative or executive branches of the state government, to travel to other meetings, or for ceremonial, civic, or religious reasons. But these exceptions only apply if no official business happens during these gatherings. So what does it mean for a meeting to be open to the public? First, the public must have full access to the meetings, which means being able to hear and see what is happening during the meeting in real time. Access can be in person or remote, such as via Zoom access or live streaming. The public is also permitted to record during these meetings, and that's something that came up very recently when a spokesperson from the Bullitt County School District asked a GSU student journalist to hand over footage of a public meeting on January 31st of this year. The school district has since returned that footage with some awareness that violated this law. However, public comment at open meetings is not required under the Open Meetings Act. The agency can decide whether to allow time during a meeting for public comment. One important exception here is that school board meetings must now include a period for public comment, and this is actually a newer law. Next, agencies must provide notice to the public before all meetings, even emergency meetings. Notice means that the public must be made aware of the date, place, and time of all meetings. For regularly scheduled meetings, notice should go out at least a week beforehand, both physically posted at the regular meeting location and posted on the agency or committee's website. For non-regularly scheduled meetings, written or oral notice must be given at least 24 hours in advance of that meeting. In the case of an emergency meeting held on less than 24 hours notice, the agency must provide within a reasonable time frame notice given the circumstances, which includes giving notice to the official newspaper with the largest circulation in that county. Next, before all meetings, the agency must make an agenda of matters expected to be considered. This agenda must be made available upon request and be posted at the meeting site as far in advance as possible, but not necessarily 2 weeks before the meeting. This gives the public the ability to assess if this is something that they want to attend and are interested in. Finally, members of the public have a right to know what happened during the meeting, even if they did not attend. So a summary of the matters acted on and who was present must be made available within 2 business days of the meeting. In addition to the summary, minutes must be kept in writing and made available to the public no later than immediately following the next regular meeting. During COVID, we obviously had to adapt and hold important meetings over Zoom. These meetings still fall under the Open Meetings Act. If the public meeting is on Zoom, the public has to be able to see and hear the whole thing clearly. And this is something that has come up recently. The AG's office went after City Council for making the audio in meetings incomprehensible and then videoing the Zoom call onto Facebook. You couldn't see anything and you couldn't hear anything. And this was clearly a violation of the Open Meetings Act. The limited exceptions to the Open Meetings laws are generally known as executive sessions. An agency may close a meeting or portion of a meeting only if a specific statutory exception applies, and a meeting may be closed only by a majority vote taken in a properly noticed and open meeting. And the most commonly used exceptions are personnel matters, attorney-client discussion of litigation, and real estate matters. If an agency does vote to close a meeting, then depending on the agency, either the person presiding over the meeting or each member in attendance must file a notarized affidavit stating under oath that the subject matter of the meeting fell under one of the exceptions provided by law. Importantly, no votes can be made in executive sessions. Votes must be taken in public, and the public must be able to understand what is being voted on. To that end, bills need to be explained. The vote can't just be on item 2 without explanation. There needs to be some clarification. Finally, I'll talk about the penalties an agency can face if they do not comply with the Open Meetings Act. All actions taken during a meeting closed in violation of the Act are void and can be set aside by a court if challenged within 90 days. Second, officials who participate in closed meetings in violation of the Act can be recalled. And finally, agencies can also face the same penalties that Richard had already discussed in prior slides. Now I'm going to pass it back over to Richard to discuss laws that apply specifically to law enforcement. Thanks.
Right. Some law enforcement specifics. Thank you so much, Isabel. I really appreciate your hard work on that. Law enforcement. Records generated during an active investigation or while the investigation is open, including interviews, contacts within confidential sources, for example, they are exempt if that investigation is still active. Not exempt are initial incident reports or the supplemental narrative to initial incident reports or public records that existed before an investigation. So if the police department is doing a deep dive into allegations of fraud in an agency and the records of the agency, the accounting records, are part of the investigation, the police department can't keep you from getting hold of those bookkeeping records, those accounting records, if they existed before that investigation began. Records in closed investigations, including all crime lab reports and photographs, and there's a little bit of an exception there, which I'll get to, relating to autopsy photos. But records in closed investigations are open. The key is, when is an investigation closed? And there's some wiggle room for agencies because they may have not worked on investigation for a year, but technically it is not yet closed. And sometimes we have to press that point. Departmental policies and procedures are always open. What's the policy for doing a traffic stop? What's the policy for handling an arrest? What are the criminal history records for in Georgia felony convictions? Out-of-state felony convictions are not public records in Georgia because the state of Georgia did not create those records, and they're provided through a federal database. So you might have to do a federal search or go to the state where someone was convicted of that felony. Again, initial incident and arrest reports are always open. Internal affairs records are public 10 days after the investigation is submitted to agency for action or the investigation is concluded. They have, under the law, a 10-day head start to be able to discipline, manage the issues internally before those internal affairs records are made public. 911 materials and computer-aided dispatch reports are public records. Certificates of training are always public records, and applications for employment. So it would be possible, for example, to track an officer and their previous employment in other jurisdictions from their applications for employment. Some mandatory exemptions. There's a lot here. Let me just have you soak those in, and I'll touch on some of the high points. Autopsy photos, going back to photos in files, are not available to the public, except to the family of the deceased. And always there's the issue of how close does the person have to be to the person who died to qualify as family. And I think it's deliberately vague under the law, and perhaps that's a good thing, allowing cousins, maybe surviving relatives. Birth certificates are not included. Confidential informants reports are not included. Child abuse reports, except where there's been a court order. Grand jury testimony is not available when it's been sealed. Interestingly, insurance company information in a fire investigation, if there's a fire investigation, the insurance company's investigation into that same thing is not available under the Open Records Act, even if it's part of a closed case. Nursing resident information, parole board records, name IDs of rape victims, unless the rape victim decides to self-identify. Personal tax information, except, of course, the records for property taxes. Tag information for a vehicle is not available for law enforcement, but you can get it from Georgia DOT. You just have to approach by a different route. And juvenile records for most crimes are not available under the mandatory exemptions. I'll let you just look those over, and I'll look in the chat to see if there's any specific. Okay. In the case of child abuse reports, can a parent obtain a copy of the report? Same for juvenile record. Can a parent get a copy of that? There may be an exemption for parents or a relative, but certainly journalists and the public seeking those records cannot. I am not sure about that, Corelli. Defer to Clare. She might have more knowledge about that. If not, we can try to circle back with you on that later. So
Sorry, just to address that question really quickly. I think it's really complicated with child abuse reports, and even for parents, it may be difficult to obtain them. So there's no one response to that question. It's going to be pretty fact specific.
There are special rules for accident reports. There has to be a written statement of need. So if you're in a wreck, you can go to the police department, write a note that says you need it to be able to get your insurance, and they will give you the accident report, or for a small fee, give you the accident report. Typically, this was written into the law to keep ambulance chasing attorneys from getting every accident report and then bombarding you with offers for you to be represented by the attorney. Journalists can file a document saying, hey, we want to report on this accident, and therefore we need the accident report, and then that can be turned over. So I think it's pretty broadly written. If you weren't involved in the accident, but it occurred in front of your house or on your street, I think you should be able to write a statement of need that allows you to get that accident report. Arrest and booking records, mugshots, require affirmation in writing that the photographs won't be placed somewhere that charges money for removal or deletion. There was a cottage industry a few years ago of Georgians who were arrested, and then their mugshots were published on these sites that then required a $500 fee to have them taken down. It was a pretty insidious business, and so the legislature changed the law to prevent those kinds of abuses. Coroner and autopsy reports require a family member to provide proof of kinship for images or videos depicting a deceased person, particularly in the stage of dismemberment or mutilation. And then the family violence incident reports, they're subject to disclosure only if an arrest is made. So if there was an incident, the police go to a house, but there's no arrest, those records are not made public. So initial incident reports. Initial incident police arrest reports generally should be released by the police or sheriff's office upon request, regardless of whether they're part of an active investigation. And that includes the initial incident report, any supplemental reports that's attached, any narratives of the report, and any similar documents attached to the initial incident report. The agency may redact personal information, including the address, home and telephone number, identification of dependents or immediate family members, but the agency cannot maintain separate internal and public versions of initial incident reports. And we saw that play out in a county in North Georgia, where the sheriff's office provided this incident report to an inquiring journalist. And that was all that was there. And they were maintaining 2 incident reports. And the other incident report, the full incident report, was kept for the agency only. And of course, it was drug activity going on that property. Marijuana plants being grown there, which of course in a small town is newsworthy in the local newspaper. The AG's office weighed in and made clear that there's nothing in the Open Records Act that allows an agency to maintain 2 different versions of a public record and to withhold the internal copy when there's no statutory exemption in the record that would keep it from being released. So pending investigation and prosecutions, records in any pending investigation or prosecution of criminal activity are not required to be released. However, records are subject to release when the investigation is concluded or the file is closed otherwise. This includes cases that are unsolved but otherwise closed. And again, initial police arrest reports and initial incident reports are always public. Police dash cams and body camera recordings in closed cases must be released in closed cases. But the Georgia courts have not determined whether the footage in open cases are open records. And here it's important to know that GBI, the former GBI chief Vic Reynolds and his predecessor repeatedly made the case that it's in the interest of the community to release records and those video records, because it lowers tension in the community, usually confirms the police account of what happens, and often encourages a climate of openness and trust. But as we've seen in some very high-profile cases, things can go south pretty fast when those records are withheld and not shared, and it undermines trust. Both Vernon Keenan and Vic Reynolds supported the records release of those police records. Mike Register, who was appointed by Governor Kemp in August, has not yet made clear his views, but given his engagement with his deputy with the Georgia First Amendment Foundation, we are hopeful that that transparency and that push to transparency will continue from the GBI. News media access. News media have the same rights of access to information as the public. And therefore, the government can't prohibit the taking of photographs in public places by journalists or even by the public. They can't limit interviews that witnesses are willing to give to journalists. They can't review, seize, or destroy photos or videos of law enforcement without a warrant. In other words, if a journalist, even a student journalist, public person, takes pictures from a public place of police activity, they can't come over and take those images from you. The news media have the right to conduct news gathering activities on property open to the public. We had an incident recently down near Macon where the State Highway Patrol was requiring journalists to leave an accident scene, walk across a 4-lane highway, then across railroad tracks and down an embankment, and not have no access to the scene of this accident while they're allowing the public to drive by and allowing the public to walk by or drive by, let's say, property. Specific attack on the news media that was determined to be excessive on the part of the State Highway Patrol. All of what we've been talking about so far can again be found in these open government guides, which can be found at the Georgia First Amendment Foundation website, which is gfaf.org. Okay, so now we're moving on to the illustrious Professor Norins from the First Amendment Clinic at UGA School of Law. I'm going to stop my screen share so Claire can share her screen. Go ahead, Claire, take it away.
Thank you, Richard. Hold on one second here. Hi, everybody. Okay, so we're going to talk about social media use by government officials and when that is subject to the First Amendment and when it is not. So the First Amendment is going to apply to government officials or government agencies who use interactive social media for official purposes. So official purposes is defined as using social media to communicate about official duties and activities, either of the individual or of his or her office. And an interactive social media account is where users or viewers can speak on that account by posting comments or emojis or reposting or retweeting the contents of the page. So if both of those things are true, if you are using a social media account for official purposes and you have enabled it to be interactive, then the government official or agency running the account is not allowed to delete people's comments or hide their comments or block the users or viewers simply based on disagreement or dislike with the content of the user's posts. So on the other hand, if the government official is having a private social media account, which many people do, that would not be subject to the First Amendment. That would be a personal account that the public official could block people from based on any reason or no reason at all. But the tricky part is that the line between an official purpose social media account and a personal account can be quite blurry. And so I want to spend some time talking about how courts have parsed that issue in terms of determining when is an individual's social media account really their personal account versus when are they using it for official government business. So first, let's take a look at a pretty clear-cut example of a government official's official social media account. So this is a screenshot of Governor Brian Kemp's Facebook page. It may not currently look like this, but at one time it certainly did. And so we see here that there are a number of indications that this is definitely an official account. So we see first that the name of the page includes the governor's title. The description of the page also includes the fact that he's a public servant who's been elected to serve as governor. We see that either Governor Kemp or Facebook has labeled this a government officials page. So that's how it's classified by Facebook. We also see that there's a link to the Georgia governor's official website. And then we only see one post in this screenshot, but it relates to official business in Georgia, talking about how jobs are strong and the business climate is good in Georgia thanks to Governor Kemp's policies. So here, this would clearly be an official purpose account, and Governor Kemp would not be permitted under the First Amendment to block people or hide or delete their comments simply based on disagreement or dislike with the content of those comments. So that's a clear-cut example. Let's look at a perhaps blurrier example. So here we have former President Donald Trump's former Twitter account. This is definitely a personal account. You see down in the bottom of the screenshot, it says joined March 2009, which was years before he became president. So this started as a clearly personal account, and there's really no bright line rule about when a personal account crosses over the line into being an official account. But let's take a look at some of the things you might look out for. So here in the example, the title of the account is just Donald Trump's name. He isn't using his presidential title. His handle is @RealDonaldTrump, again, a personal handle. However, once he was elected to office, he added 45th President of the United States of America. So now this is looking a little bit more official. He also lists his residence or location as Washington, D.C., which is where the White House is. Donald Trump's personal residences were in Florida and New York, so another indication that perhaps this is an official account. And then the photo is a picture of an official event. So again, an indication that maybe this is becoming an official account. So let's look at the things that the courts consider. So the first thing they're going to consider is this account publicly accessible to anyone who goes online and wants to view it? Or on the other hand, is it an account that you have to friend the person to be able to see it? If it's a publicly accessible account, that's going to weigh in favor of it being an official capacity or official purpose account. Then the courts will look at, does the account include the official's title? Are there trappings of the public official's office, meaning like links to their government website or government email or pictures of them engaged in official government activity? But these last two factors are the most important. Is the account being used to communicate with constituents or with the public about the official's duties and activities? So that's probably the number one thing that the courts are going to be looking at. And then secondly, most important, is how does the public official themselves treat the account, and how do other people, either members of the public or other government officials, treat the account and interact with the account? Are they treating it like a personal account, or are they treating it like a place to discuss and communicate about official government functions? So in this case, this was a real case. President Trump, former President Trump, was blocking people on his Twitter account because he disagreed with what they said if they criticized something he did or one of his policies. And he was sued, and this was in the New York courts. And the courts held that even though this account started as definitely a personal account, once President Trump was in office, he switched over to using it for official government purposes and business. And so it became subject to the First Amendment, and the courts held that President Trump had violated folks' First Amendment rights by blocking them. So a word about campaign or election social media pages. These are generally considered private, even if they're run by somebody who's an incumbent, who's already in office. But again, these accounts that start out as private can change in character and nature over time to become official accounts that would be subject to the First Amendment. So for instance, if you have someone who started an election Facebook page, and after they won and were in office, they continued to use that same page to communicate with the public about what they were doing in office, the page then may have shifted to become an official capacity page, no longer a private page, and the individual operating the account would no longer be able to block people based on dislike or disagreement with their comments. So I want to talk a little bit about best practices for government agencies or government officials who are operating social media accounts. And the first thing would be, it's ideal if you are operating an official purpose account to have a policy about what this account does and how folks can interact with it. And I'll talk in a minute about some key elements of a social media policy that would be good to incorporate. Another thing to keep in mind when government agencies or government officials are running a social media account is that there's going to be some First Amendment no-nos potentially. So you can't block people because you don't like what they're saying. You can't remove or hide relevant comments because you disagree with them. And you can't limit users' access to any of the interactive features on the page simply because you don't agree with the views or opinions that they're expressing. And if there's a concern that a user is violating the platform's community standards, for instance, Facebook has a community standard that prohibits hate speech. If there's a concern that that's being violated, the correct response would be to notify Facebook of the concern and to let Facebook address that user, because it's really not the government officials or the government agency's role to enforce the platform's rules or standards. That should be left to the platform. So in terms of what a social media policy might look like for an official purpose social media account, the policy is going to need to explain what the general purpose of the account is. Is it a place just for the government official or agency to communicate out to the public relevant information, or is it a place where folks are encouraged to share their ideas and comments and views? That should be explained in the policy. The policy should also explain any limitations that are being placed on how users can interact with the account. So it is permissible for government agencies or government officials to limit what topics can be discussed on the page, so long as those limitations are reasonably related to the purpose of the account. So for instance, if a school board has a social media page, it would be okay for the policy to say, this is a social media account for discussing issues related to the schools in our county. And we reserve the right to remove, off-topic comments if they don't relate to the schools. That would be permissible. Any limitations that are placed on how users interact with the account should be very precisely defined. So for instance, saying things like, we don't allow abusive or harassing comments on this page, or we don't allow hate speech. Those are vague terms and they mean different things to different people, and so they don't properly put folks on notice of what is prohibited on the page. So those can raise First Amendment concerns, which is why it's suggested that you use very precise language about what you are saying people can't post or say on the page. Limitations also cannot be based on viewpoint. So if a policy were to say, we don't allow people to post complaints or grievances on this account, this is not a forum for complaints or grievances, that's a viewpoint-based limitation, because it's saying we don't want to hear negative things on this account. You can say positive things, you can say neutral things, But if you're complaining or expressing a grievance, we reserve the right to remove you or, delete or hide your comment. That would be a viewpoint-based form of regulation, which would be prohibited under the First Amendment. It is, however, okay to prohibit speech on the account, comments on the account that fall outside of the First Amendment's protection. So the First Amendment does not protect all speech. There's lots of exceptions to the First Amendment. And so it's okay to block content that falls into one of those recognized exceptions. So truth, a statement of intending to inflict imminent harm on someone. You could prohibit that and delete that if it was posted. Incitement to unlawful activity is another exception to the First Amendment. Obscenity, those things can be prohibited on the page. And finally, it's okay to decide as a government official or a government agency that you don't want to have an interactive page. Maybe you just want to post your information or your content and you don't want to allow other people to comment. But if you make that choice, it has to be uniform. You have to eliminate the ability for anyone to post or comment on the page. You can't selectively choose who can post and who can't. So just to recap, if you have a social media policy as a government official or government agency, you want to explain the general purpose of your account. You want to explain precisely any limitations on how users can interact with the account. And also the policy should explain how the limitations will be enforced. So if you choose to have limitations, you need to enforce them consistently and in a viewpoint neutral way. Because if you start to enforce limitations against some people but not others, it again becomes an issue of you're selecting which viewpoint you want to suppress. So limitations need to be vigilantly and consistently enforced. And then ideally, the policy should provide that there will be some due process for people who disregard the limitations. So that means that they'll be notified if they're being blocked or if their comments being removed and given a general explanation as to why. And ideally, they should have a chance to appeal that decision or perhaps after a period of, being blocked, be allowed back on. And only if they repeatedly violate the policy would they be permanently blocked. So just a couple of things to keep in mind when you have a government official who has a personal social media account that they want to keep personal. These are some best practices to make sure that there is a clean line between a personal account versus an official capacity or official purpose account. So for a private personal account, you want to set, or the government official would want to set the settings so that not just anybody can go on and see this page, that you have to actually friend them or be in their network to see it. They would not want to associate their official government title or address or email with the account. They would not want to encourage constituents or members of the public to contact them through that account about government business. They should refer folks to contact them through their official account or through some other means. The personal account should also not link to other government websites or social media pages. The government official would want to be careful not to cross-post the same content on both their official page and their personal page. You see that not infrequently where a government official has like their government county Facebook and then they have their personal Facebook, and you'll see all the same posts on both relating to official business. That's making it very blurry. And it exposes the official to a court finding that their personal account is actually an official account subject to the First Amendment. The government officials should be careful about posting pictures on their personal account that shows them at work or carrying out their official duties. And then ideally, the personal account would be limited to personal topics friends, family, vacations, hobbies, pets, and not discuss, official duties or activities. So these are some of the factors that the courts will look at. And so if any of the boxes aren't checked, a government official operating a private social media account runs the risk that a court might find that it's crossed the line into being an official purpose account where they can no longer block people at will. So that's a general overview of how to sort of have good hygiene about personal versus official purpose accounts if you are a government official, and if you are interacting with government officials on social media, these are some things to look out for. So now I'll turn it back over to Richard to sort of wrap up our formal presentation, and then we'll some of the questions that were in the comments.
So thank you so much, Claire. As we move into the questions now, to give Claire some time to look at the chat, and particularly in the areas related to social media, I'm going to answer some of the initial questions. There's one here that sort of flops into the social media area, but I think it's in relation to mugshots and arrest information. Carson asks, if a social media account posts mugshots or arrest information, would they be required to take the post down if the featured person reached out for removal, even though it's publicly available online? The restrictions for providing mugshots are to sites that specifically charge for taking an image down. So if somebody posts a mugshot that they legitimately obtained, there's no requirement to take that down. As a nice person, you might want to do that. There's a lot of discussion within news organizations now about when someone has a right to be forgotten. And this is particularly a big issue in the European Union, where there have been laws passed allowing people to petition news organizations to take down stories that name them for their criminal activities years before. That has not yet come to the United States, but certainly a lot of newsrooms are thinking about that at a time where it's one thing to go to the library and leaf through back issues of the papers that are bound. It's another thing if you can sit in your living room in Atlanta and read back copies of the paper in Dahlonega and see the arrest records in those back papers. So that is not yet defined law in the United States. When body cam is supposed to be released when a case is closed, do we still need to redact due to dates of birth given and officers holding ID cards, etc.? I think that's probably an area of law that is a little squishy too. Certainly, are you showing a close-up of the ID card on the screen or the date of birth on the screen? I think there's probably questions about how much those images would actually show, how much of a document that's seen on a body cam video or a dash cam video that actually shows that detail. Joe asks, if the Georgia Attorney General's office does not seek a criminal case against a person for violating the Records Act, how does the Open Records Act empower an individual to get a court to prosecute criminally? There really isn't an empowerment for an individual to get a court to prosecute criminally. You could, though, file a civil action. It's on you for the expense of that civil action.
Here only tries to be nice.
I would, whoever's just speaking up, if we could get you to mute, please, that would be terrific. To what extent are open meetings laws flouted when meetings are held long distance from jurisdiction on private property behind places with entrance fees, e.g. stone mounted for elected body retreats? I would argue in the case of Stone Mountain, certainly, that that's a parking fee. And just as anybody would pay for parking when you go to the legislature or perhaps a county commissioners meeting in downtown Atlanta, or that's kind of the cost of doing business for going to that meeting. If they were to charge for admission into the physical place at the Marriott Hotel, for example, where the elected body, that's a different thing. Certainly, if they choose to do it in another jurisdiction a long way away, that's their prerogative, as long as you're able to attend that session.
And Richard, if I could jump in for retreats and trainings, those are excluded from the Open Meetings Act so long as official business is not being discussed. You know, if it's just to educate the members, that does not have to be open to the public. Of course, you know, the line can be blurry about when do you cross over into discussing official business, but there is an official exception in the Open Meetings Act for training sessions.
Although many jurisdictions, to be fair, also do open those up because they don't want to cross that blurry line or be accused of crossing it. So I think that also depends by jurisdiction, right, Claire?
Right, that would be up to their discretion and certainly a best practice from a transparency standpoint.
And we've conducted training in North Georgia for police departments where the police department has welcomed people in from the public because they want the public to see what the training is that they're doing. So it's not, certainly attending training is not prohibited by the Open Records Act, although Claire's absolutely correct that there is an exemption. They don't have to let you in. Can a requester avoid being charged by making many small requests instead of one large one? So if a requester provides a list of 100 incident reports in one request, it could take a few hours to complete, it would be sent a bill. If they make one separate request, each request may only take a few minutes and under the 15-minute fee exemption. Well, yes, technically you could do that. I would just refer you back to what your mama told you about being nice and playing fair by the law. And if you're going to make a big document request, I think you probably need to acknowledge the fact that you are liable for the cost of doing that work. If you're doing it different days, a request on different days for different things, sure. Over the course of a year, 100 requests on 100 different days, I don't think that they would be covered under the fees. But 100 on one day or over 2 days, I think just ethically as a journalist or a public person asking for those records, remember what your mama said, be nice. If a social media account posts mugshots and arrest information with it required to take the post down, I think I covered that earlier. Legislators demanding no photos in the open gold dome areas during a press conference. So the legislature has this special exemption, and they also control their space under the House rules, which change every session. And this session, they have prohibited private photography in the chamber and the spaces outside the dome. We don't like that. I think it's a further closure off of transparency in the legislature, and it's disappointing, but it's their building. They get to make the rules. And so we have to abide by those rules. That doesn't mean to say that that's a good thing. And certainly we can press our legislators to commit to opening up that space. Let me just make sure, let me scroll down here, make sure there's none.
So Richard, I'll go ahead and address some of the other open records questions that came up. So there was a question about statute of limitations, and I put in the chat that it's generally 2 years. However, if it's an ongoing violation where, say, you've made a records request and there hasn't been a response, the whole time that the violation is occurring counts. So, like, if you've made a request 6 months ago, your 2 years would start from like today when they're still not giving you the records. But generally 2 years is the statute in Georgia. There was a question about if you have an open records dispute and you've had an attorney intervene or appear on your behalf and write a letter to the mayor or some other government official, is the communication between the attorney and the government official subject to the Open Records Act? And the answer would be yes. Let's see. There was a request about
their attorney responding to the mayor about making a decision. That would not be open. Right?
Correct. So their own communications with their own attorney would be privileged, but communications with an outside attorney who is like in an opposing party kind of situation, that would all be subject to the Open Records Act. There was a request about or a question about requesting bulk data, and certainly you can make a request for bulk data. There may be fees associated with that depending on how much data and how much labor is involved in making that data available to you. Requests for bulk data cannot be a standing request that you get production of not yet existing records. You can only request what already exists. And then if you want some more time to go by and then you make another request for new records that have been created, that would be fine. But I think the question seemed to suggest that there was a desire to have sort of an ongoing obligation of the agency to keep producing records to you as they get created, and that's not contemplated by the Open Records Act. And then there was an open meetings question about members of the governing body getting together ahead of time before the meeting to discuss matters, so that there's no discussion at the meeting, everybody just votes. That is a problem, and certainly if that could be documented and proven, that would be grounds for a lawsuit, alleging violation of the Open Meetings Act. Other ways to combat that would be to speak up at the public comment sessions, if that's allowed, if there is public comment during the governing body's meeting, to draw attention to the fact that it seems like the members have met ahead of time and made their discussions and decisions in private before coming to the meeting. Writing about that in a letter to the local paper could be another way to bring attention to it. I mean, ultimately, these if these are elected government officials, they're accountable to the voters, and the voters should know if they're not conducting government business in the open.
I'm picking up another question. What's the rule, law on agencies publishing or naming an open records custodian? So many don't. They are supposed to disclose on their website that there's an open records custodian. Certainly if you call there and ask them who is the open records custodian for this agency, they're supposed to tell you. Otherwise, you just send the open records request to the agency and it might get forwarded to that custodian. If they have a custodian, though, they can't deny you the records or slow the process from getting you the records just because they have a custodian you don't know the name of. What should be done if a citizen has reported to the state infractions of either open records or open meetings and never hear back from the state on those things? If you, Kathy answered this really nicely in the chat. If you think you're improperly denied public records, start by submitting a complaint to the AG's office. Your complaint itself becomes a public record documenting your complaint. And I think that's great advice from Kathy. There were several questions, Claire, relating to the social media presentation. I don't know whether you got to scroll back up and see some of those.
So I think there was a question about can government officials be required to have a social media account to communicate with constituents? And no, I mean, there's no requirement that they do that. I think it's very common that government officials and agencies find that social media is the cheapest and most effective way to communicate with the largest number of people. But if they choose not to do it through social media, that's their prerogative.
Michelle asked a question related to body cam videos to use for YouTube or social media views. Is there any gray line to this? The cases are closed. My take on that is that those are then public records and can be published on a news site or a social media feed, YouTube or wherever, if the individual finds value in posting them in those places. They are public records.
And to add on to that, it's improper for a responding agency to consider the motive or purpose of the requester in asking for the records. People are allowed to request public records for any reason or no reason at all, and they don't have to explain their reasoning. So I think that goes to what Richard said, that if they request the public record and see value in posting it, that is perfectly allowable.
I'm seeing two more posts down at the bottom here. Is public comment required at all school board meetings, even specially called meetings? My understanding is yes.
I would just qualify that by saying you would need to look at the wording of the law on that to see if it states, regularly held meetings must have public comment or all meetings. I'm actually not sure on that point. So I would just say check the language of the law.
I think we have answered all the questions. If somebody has not had a question answered, if you will slap it back in the chat, just cut and paste it back in the chat. We'll just pause a moment here to make sure nobody has. And then, this is Jennifer from the Attorney General's office. If you submitted a complaint to us but don't receive a personal response, please send your complaint direct to me at jennifercolangelo@law.georgia.gov, and also to my colleague, Kristen Settelmeyer at ksettelmeyer@lawgeorgia.gov. I have to tell you that Jennifer has been really, really responsive to us in the past and to those who need support from the AG's office. Even if she's not able to help, she may have just great wisdom on how best to manage.
I think there was a question about our juvenile records available if being tried as an adult. And I don't know the answer to that. I would imagine that if you're just a member of the public seeking someone's juvenile records, even if they're being tried as an adult, there's going to be barriers to obtaining those, but that's a question that would...
I can actually step in here as a retired journalist.
Okay,
As a retired journalist, juvenile records were always available in courts when they were being tried as an adult. It basically wiped the juvenile section off the case file. Where it got tricky was when you had 3 juveniles and only one was being tried as an adult, and then it got mushy and it became difficult to get everything because if they were all intermingled.
Well, I just want to thank everyone for attending today's webinar, and please feel free to reach out to the First Amendment Clinic at UGA or the Georgia First Amendment Foundation if you have additional questions.
Thank you, Claire. Thank you, Isabel, for your participation, and thanks to everybody who joined today. Really, really appreciate it. Take care, everybody. This video will be posted to the Georgia First Amendment Foundation website within the next couple of days after we get it turned around.